Good morning, everyone, and welcome to Startups in the Law, presented by JonesKertz and hosted by Capital Factory. Before we begin, just want to give a special shout out and thank you to Capital Factory for hosting this. They've been our partner with this for almost 2 years, and they do a fantastic job at hosting this event for us and putting it on. If any of y'all are ever interested in doing some other events or listening in on anything else, feel free to go ahead and follow Capital Factory on YouTube, follow them on social media. They're pretty active there. Aside from that, let's go ahead and get started. So to give you an idea of our law firm, so we are primarily a tech startup law firm, okay? 90 to 95% of my client businesses are gonna be tech startups. About 5 to 10% are going to be, other businesses, real estate businesses, mom and pop shops. We have all other kinds of businesses, I'll tell you. But primarily we focus on tech startups. We focus on tech financing. We focus on contracts that those people draft. That said, to give you an idea, we have an office in Oklahoma City that's headed up by Matt Jones. You'll notice that Matt Jones's email address is slightly different than mine. That said, we operate by 2 separate names in 2 separate states because of the weird rules related to naming law firms in the state of Texas versus the state of Oklahoma, though that is soon to change. We are actually going to be going by Verge Law here in Texas and throughout the rest of the nation starting on January 1st, which we're extremely excited about. We're currently rebuilding our website and merging everything together once and for all. That said, I head up the Dallas office. Dallas is our headquarters. That said, we also have a presence in Austin now. We are, as of a couple of months ago, we hired our first employee in Austin, and we are about to hire our first associate attorney that is going to be based out of Austin. So we are super excited about being there. That said, if you have a question that's related to Oklahoma law, I'd encourage you to reach out to Matt Jones. If you have a question related to Texas law, or just a general question about startups or Delaware law or something like that, feel free to email me at kyle@joneskertz.com. I usually try to be pretty responsive. That said, in the event you have any questions live during this event, please go ahead and drop them in the comments section. I'm going to be actively looking at that throughout this webinar to make sure that we can actually get to all the questions that you want to ask, even though we might not be addressing, those categories or those subjects today in full. Okay. Moving on. So here's a little bit about our mission here. Startup lawyers, as business lawyers, we see the value that our relationship to our clients, provides in the long term. And what we mean by that is whenever we come in early and help structure a business and help draft the contracts for it, we usually are able to educate, and we're usually able to make sure that these clients have a lower rate of failure. I'd say, I'm pretty proud that our clientele, more than 9 out of 10, more than 9 out of 10 of the companies that we have ever started have not failed, which, I attribute, number 1, to the education that we provide. I attribute, number 2, to the foundation that we provide to our clients, and I think that does actually lead to more successful startups. And that's what you see here. We sit these people down at the very beginning of that relationship, and we explain to them the basic things and the necessities of starting their business, and give them, I would say, a more specific path forward for their companies, which is what a lot of people don't have for the first year or 2 whenever they're starting out. We basically truncate that timetable a little bit, get them ramped up a little bit more. We get them ramped up a little bit better, and provide them a lot more protection and a lot more knowledge on the front end. That said, not every business succeeds, or not every business goes gangbusters. So, we can't say that all of our businesses have ever been successful, because at the end of the day, it truly is on the particular founder. It truly is on the particular CEO or the person managing that business. But I will say, our track record is pretty good. If I was estimating it, I'd say about 95% or more of our client businesses, go on to live for at least 2 years, if not longer. So aside from that, though, topics covered today, we're going to go over legal and startup news update. That's usually what I address in the first, 5 minutes of actual, going through this webinar. And then we're going to go into seed stage financing and Series A financing. I'm basically going to do a step-by-step on seed stage financing and the things that you need to know from a high-level overview. But I'm also going to go down into, more what I would call, the nucleus of a seed stage financing. We're literally going to get down there and actually talk about some of the things that you need to know and make sure that you do when you are going through your first financing for your company. Okay. As far as this webinar goes, we're going to be addressing these topics. So if you have any other questions, feel free to drop them in the comments. I know if we might not be addressing these, anything else directly here today, I'll at least try to get any of your questions answered, and we can take a detour for a little while if necessary. Okay. Other than that, I have to do a legal disclaimer because I'm required to by the state bar. You should know that this is not legal advice for you or your business. This is not designed for you, and none of you are my clients, unless you actually are, in which case, welcome. Please don't act on this info without seeking advice from your attorney or an attorney that is qualified to practice this type of law in the state that you are in, or at least the country you are in if you are joining us from somewhere else. Keep in mind, whenever we're practicing law, there really are no absolutes. We frame everything based on the facts, and we conduct research to reach legal conclusions. We never make just a one-off decision or an answer based on a gut feeling. We make sure that we back everything up with the law. We make sure that we back everything up with experience and knowledge and know-how. Okay. So, and last but not least, remember, you are not a lawyer unless you are one, in which case, unless you're a business lawyer or a startup attorney, don't try to do any of the stuff I'm talking about with at least doing research or at least seeking out counsel for yourself. Even though you might be a lawyer, I know plenty of attorneys that are really not qualified to do this sort of thing, and I've seen them try and fail miserably. That said, as far as starting businesses go, I should say that anyone can start a business themselves. That is not the practice of law. What is the practice of law is drafting contracts and doing other things that might be a lot more sophisticated than the normal layperson is able to do. I would encourage you to not do those things because more often than not, you shoot yourself in the foot and you come to somebody like me to fix it. That said, this is about, providing you with more direction and knowledge about where you're going to be going with your company. So let's go ahead and get right into the content here. So, and I want to say something before I go any further. I know that, we are primarily tech startup lawyers, but keep in mind, we operate in the cannabis space as well. We have cannabis clients who sell at the retail level as well as operate grow operations in both Texas and Oklahoma. So just keep in mind what I'm about to talk about is actually startup oriented. It's just not tech startup oriented. Okay. You might have heard in the news that lately Delta 8 has become increasingly popular, right? Delta 8 THC is basically a derivative form, from other cannabis plants. It can be derived from either marijuana or it can be derived from the hemp plant. Technically, if you're deriving it from the hemp plant, it doesn't really occur in quantities high enough to get high on naturally. So technically, there would have to be some sort of refining process that allows us to create concentrations high enough for you to actually get high from that stuff. And this has been a big topic of discussion amongst cannabis lawyers in the state of Texas. I've actually spoken with attorneys who are arguing that technically, Delta 8 is legal under Texas law. And then I've spoken with other experts who say, absolutely not. The law does not say that. If you've been regularly attending our webinars, you might recall that we actually did a bunch of research on this and presented on it. And our conclusion was that Delta 8 THC, because there is no way to legally manufacture it in the state of Texas or legally possess it in the state of Texas, that it was indeed fully illegal to sell it. It was fully illegal to own it. It was fully illegal to transport it. You could be guilty of drug trafficking for doing so. That said, I don't want to act like the sky is falling. A lot of people and a lot of law enforcement agencies are not actually taking this as seriously as other types of drug trafficking, like cocaine trafficking and methamphetamine trafficking and things like that. They're not, But I do want to say in more conservative counties, so I'm not talking about Dallas County, I'm not talking about Harris County, and I'm not talking about Travis County. I'm not talking about Dallas, Houston, or Austin. I'm talking about more conservative counties in the state of Texas where, they might be, smaller towns. They have actually gone in some cases and actually arrested the proprietors and shut these businesses down that are selling this stuff. And, you'll see this photo here that we've had up for a while. It says that, Texas Department of Health and Human Services actually did indeed declare this fully illegal the other day. That said, some of the lawyers are actually arguing that that was not proper. They're saying the procedure for which that under which that determination was made was actually wrong. And to be honest with you, I don't know it's true at the moment. And as far as what we say about these things, there are several lawsuits that are actually out there right now. That there are several lawsuits that were actually brought right after the Texas Department of Health and Human Services declared it fully illegal, and basically, I guess, tried to make an attempt to clarify the law that, I guess the Texas state legislature thought was clear enough at the time they drafted it, which, by the way, I've read it. It really is not very clear. It has some very specific stuff. And actually, you have to get down, whenever you're analyzing this issue, you get down to the chemistry of Delta-8 THC. And at that point, that's when we figure out, oh, yeah, it probably is illegal because of the way the chemistry really works here. That said, when it comes to, when it comes to the legality of this, we are, when it comes to the legality of this, we're sort of waiting on the courts to make a determination here, which could take some time. It could take anywhere from 6 months to a year or longer, I'll tell you. And this is potentially something that could go up to the Texas State Supreme Court, if not the actual Supreme Court of the United States, because some of the arguments here are actually based in constitutional law. And I'm not going to go into, the chemistry here and all this other stuff, because I sort of talked about it in a roundabout way. But, the major takeaway here, is basically this slide. Okay, so, like I said, the DHHS, declared this illegal in any concentration. They clarified not just Delta-8, but Delta-9 exceeding 0.3%. That said, here's the question. How do we determine what is Delta-8 and what is Delta-9? It takes a test. It takes a lab test if we're testing, something that's, in a bottle, or something that's, being sold over the counter in one of these stores. The key point here, though, is that federal law, did not preempt state law on this subject, in our opinion. Okay, but that is up for debate. Some people believe it did, especially the people who are operating those businesses in the state of Texas. They fully believe that federal law preempted state law, but that's not the way I read it, and that's not the way the Texas legislature and this regulatory agency actually reads it. That said, what I do believe is true, and what most people will agree on, is that federal law actually did allow this, the individual states to create their own regulations regarding Delta-8. Obviously not a problem for the preponderance of states that have actually already legalized marijuana in some way. They don't see it as illegal there, and they're really not going to regulate such a thing if they're claiming that this is not marijuana. But usually, but I'll tell you, as far as where we see this going, we've seen reports that some people, in Texas, the businesses that do this are basically saying, no way we're going to stop selling this, right? I've also seen reports that certain individual law enforcement agencies have, in an unwritten manner, I guess, advise these businesses that you can sell the inventory you have, you just can't bring any more in, which is problematic because it's basically a law enforcement agency telling a private entity that, hey, you're allowed to break the law under our supervision, which makes no sense. That's not the way law enforcement works. That's not the way the executive branch of government works. So this has created some sort of gray area, despite the fact that the Texas Department of Health and Human Services has made it, very black and white for us. That said, as far as I have read, there is not a temporary restraining order on this regulation or anything like that. There has not been anything instituted negating this, clarification of the law by this regulatory agency. So, if you're in possession of this stuff, if you're selling this stuff, if you are transporting this stuff, you're particularly at risk for, at minimum a misdemeanor for possession, at maximum certain felonies, which actually can be compounded in the event you get arrested for this sort of thing. That said, the people who might be arrested for this thing are kind of what I would consider to be a pariah. They're sort of the people who have been arrested for this. It's going to be interesting how this plays out, because effectively the criminal, the prosecutors will have to indeed prove this issue in court, that yes, for sure, Delta 8 THC is indeed illegal, and it's going to be argued over and appealed over in the event of a conviction. That said, I'll say, they ought to just drop these cases. The Texas state legislature, in my opinion, should have been far clearer about this issue if that's what they intended, and they should just amend the legislation, and they should just make all of these issues that have been created moot. They have the ability to unilaterally do that and do it right now, which I think would be the most efficient legal way of doing that. That's all I want to say about it. We're going to go into the core of what we're talking about. If you have any questions about that or need to talk to somebody about cannabis law, feel free to hit me up at that email at the beginning, Kyle@JonesKertz.com. We do a fair bit of this. We also do a fair bit of, we also do a fair bit of advising people on starting, marijuana businesses in Oklahoma. That said, I am not allowed to actually do that sort of thing in this, because I am licensed in the state of Texas and not licensed in the state of Oklahoma. So basically, if you're interested in that, you need to contact Matt Jones, or you need to contact me so that I can introduce you to Matt Jones and let him take it from there. Okay. That said, seed financing. I want to talk about this just in general for a quick second. Okay. So, this is going to apply to the people that have existing businesses that are looking to raise outside capital from passive investors. Okay. Or at least, investors that are the type that, invest in private businesses, private tech startups, things like that. This is, probably the highest volume stage that we serve as tech startup lawyers. Most of the people that we serve are going to be in that early stage to Series A stage, which is why we're addressing this as a topic. Now, it's possible that you could have had a stage before this. You could have done, some angel investments with people, friends and family. People will say friends and family round. I want to make it clear that what I'm talking about here assumes that you have either done a friends and family round, or you've skipped the friends and family round altogether, and you are going straight to seed stage financing. That said, obviously, your friends and family could potentially participate in a seed stage financing. I'm not saying that would never be the case, but the idea here is you might be taking more serious capital from investors who have a lot more experience in this sort of thing, whether they be private individuals or whether those people be institutions who do seed stage financing as a venture capital firm. Okay. And this will apply to a lot of the people that are in Capital Factory. It applies to a lot of the people that are in Austin. It applies to a lot of the tech startups in Dallas and Oklahoma City. So, I feel like this is going to be a fairly relevant discussion. So please feel free, jump in, ask questions, pick my brain while you have me here, because quite frankly, I know a lot about this stuff, and I can sort of, shorten that learning curve for you in about 30 minutes worth of time, so long as, you engage and discuss this with us. Okay. So step one. Okay. Really, whenever you're raising money, the first step is you do need to figure out how much money you need. It is not vitally important at this step that you figure out how you're going to raise it. You really just need to figure out what your capital needs are. So, and most people have a very good idea of that. They're shopping the software that they know will allow them to run their business, and run it at that next level. So, you might not be, paying for the lowest end software because it's the cheapest. You might be going after that type of software that allows you to do the utmost, the utmost so that you can provide the best customer experience for the people you'll be selling this stuff to. so that you can actually host the services that you need to, for example, hosting transactions or potentially hosting video. If you're, doing something where you have to host video and you need server space, as far as capital needs go, you need to get very, very, very granular with how much capital you're going to need. I would sit down and actually spreadsheet that out and figure out, okay, here are the vendors, that we've interviewed with. Here are the people that we have done sort of demos with, as far as, integrating their software with whatever we're creating, right? Figure out what your capital needs are going to be so that you can actually go out there and explain to these people, what you're going to spend the money on. Because, a lot of people in general know that the money that you're spending is going to be spent toward product development. But really what that means is that, you're going to be paying software developers, or you're going to be paying, people who can actually, figure out how to build whatever it is that you're doing in whatever way they need to. And then, beyond that, it's, a part of the product development is, building out the internal resources, building out the infrastructure on the inside of the business to be able to go forward and actually run and operate software, sell hard products, things like that, right? Logistically, this is the most vital portion of how you plan your business. And I would sit down and actually plan it fairly well. To give you an idea, like even for our business, which I will say is very simple and straightforward to run, I sat down and before I bought any software, I interviewed, like I did demos for software for like 3 or 4 weeks before I bought anything. I made sure that I used it for free for the most part before I ever did anything where I might have actually spent $1. And you can actually ask for some things like that, from certain vendors. They'll give you, a free trial of 7 or 14 days, and you should play around with it and figure out, okay, is this actually going to work, or is this, a couple steps removed from what I need, right? I would refrain, by the way, unless you're developing the software that you need in order to run whatever it is that you need, or, provide the customer experience that you're going for, building a mobile app. I would refrain from building, certain kinds of software for yourself, unless, of course, you absolutely need that functionality to make it work, right? Because a lot of these things that I'm talking about are more like, the HubSpot, right? I'm talking about, what you'll spend on Carta. I'm talking about what you'll spend on, all the other stuff that makes your business run and operate, especially once you've done a financing. That said, keep in mind, I don't really give a ton of business advice, so this is sort of limited. But one of the considerations you need to keep in mind too is, once I've raised money, what does the timeline look like for how I spend that money? Because what I generally tell people is you need to give yourself 6 months worth of runway before your next financing, because otherwise you will be in a bind. Otherwise you will actually get to the point where you're going to have an issue with you're going to have a capital crunch situation. And I will tell you, your employees, even if they've only taken equity and they're not being paid cash at the moment, they're going to be fairly frustrated if they can't spend money to make things work, or if you're defaulting on invoices for stuff that you owe as a company. So make sure that you're providing for these capital needs and planning for that, so that, I'm not trying to say this is how you need to talk to your lawyer, but you need to give, us, 2 to 4 weeks to make sure everything that we're drafting for you for your next financing is in order. We need to be able to come in and assist you with the fundraising, okay, and get the contracts drafted and, put people on the projects and things like that, okay? That said, one of the considerations, will you earn revenue, or is this a total cost until the next financing when, you are going to monetize the business? So you need to figure that out and figure out, okay, ballparking this, you're still looking at your business model, but can I actually, make, money on this at this stage? Will anyone pay for it at this stage? Or, is this sort of hopeless at this stage and we're still in the product development phase, so we don't want to charge for it until we get to the next phase, okay? And then, aside from that, will the founders need to pay themselves stipends from the capital raise to pay for basic living expenses? This is an important thing people miss. whenever we do this. Not everybody needs a stipend, right? We've had people who come to us and they've already had a previous exit where they made plenty of money. They don't need or want a stipend because, quite frankly, it's just a drain on the capital for their business. So they don't pay themselves that, like even if their living expenses are like $4,000 or $5,000 a month, they'll just, eat it, because they've got a little bit of savings. If you're not that type of person, though, you do need to build in, a stipend for your living expenses. You need to calculate what you need to live, and that's not what you need to be happy. Okay. It's what you need, from a basic core standpoint so that you don't get evicted from your apartment. You don't, get kicked out of your house because you can't pay a mortgage. It comes down to, how much runway do you personally have? And, what's the bare minimum that you need to live off of? Okay. That said, I'll tell you $3,500, is pretty good as far as, what people usually build out for as a personal stipend. If you live in a different area like Houston or, Dallas, you might not need $3,500. You might be able to get away with $2,500 or $3,000, but Austin, I would say minimum is probably going to be $3,500 at this point because you can't really live on less in Austin and be, comfortable enough to, or I guess be comfortable enough to run a startup business, right? And if you're raising, by the way, $250,000 or $500,000, that amount of money is not unreasonable. You're talking about, 3,500 times 12, which is going to come out to somewhere around like 40 grand ish. So, I don't think that's bad at all. Here we have a question here that says, is that $3,500 a month? I'm just giving you, a round number here. Okay. So that for reference, right? So Dana, I'm just saying, just look at your personal needs, look at what you need to live. Obviously if you're living with somebody and they have auxiliary income coming in as well, you might not need a $3,500 a month stipend. You might need something less, but this is more a matter of just making sure that, your minimum needs are being taken care of. And I'll tell you, like the people who know that, the people who invest in companies and invest, they're sort of investing in the people that are building those companies as well. Sometimes if you tell them, hey, I do need a stipend because I'm, while I do have experience in building business, I don't have, a year's worth of money saved up to be able to do this for free. It's okay, by the way, when you're having that conversation about the stipend with the investor, that you bring that up and tell them that you need it. Okay. Because they'll be able to factor that in whenever they're making their investment. Because I have actually had some strings attached to some investments. We actually had a convertible note that fell through because the founders actually did need a stipend. And the investor who was putting 100,000 in didn't want to give it to them. They didn't want to allow these people to pay themselves just a basic, $30,000 a month or $30,000 a year between the two of them, just to at least shore up some of their living expenses. So it's not $3,500 a year; it's $3,500 a month. I've talked with people about that, and I know what it costs to live in Austin too. Because we have employees there, and I'll tell you, it's kind of difficult to live off of less, unless you're being extremely frugal. But that said, this is not meant to make sure that you have savings, right? It's meant to make sure that your bare minimum needs are taken care of. So I actually am going to talk more about convertible notes here in a second. So here we go. So figure out the legal instrument you'll use to raise capital. So like I said, we're about to talk about this. The three major types of instruments. So for corporations, obviously, you do a stock purchase agreement, either, a simple agreement for future equity, AKA SAFE, or a convertible note. And I want to talk about the differences between these three instruments. So this is assuming that, the business itself is a corporation. So if you have an LLC, let's say somebody was purchasing equity outright in your company, instead of a stock purchase agreement, you would use what's called a membership interest purchase agreement. Okay. slightly different, but it's the same beast. It basically has all the same terms in it. Okay. A stock purchase agreement is usually straight equity. Okay. Usually it's just cash for equity. We're not doing anything special there. Once the person pays their cash, they receive their equity. We're going to calculate the exact number of shares that person gets. And usually the way that comes about is somebody will go, it needs to be 2.5%. Or, I'm buying 5% of the company or something like that. Right. And so we'll go into an Excel spreadsheet, or we'll go into Carta, or we'll go into some cap table software, and we'll help, we'll basically run the calculation and calculate the number of shares. Right. As far as, as far as these agreements go, there's some other terms that can be incorporated into them, such as rights of first refusal, rights of first offer. I've got as far as some other terms, some people in those agreements might ask for anti-dilution. I know for a fact, let's say, for example, that, you have an early investor and they're investing a lot of money, and it's, let's say, you're doing, $250,000 and this person's going to put $200,000 in, normally I would say no to anti-dilution, but sometimes if somebody's about to give you that much, I might try to negotiate with them and say, we might set a floor, we might try to do something, similar but slightly different, if we can avoid it. I will tell you, whenever you're talking terms, I try to avoid anti-dilution, as much as possible. I've heard some other people and some other lawyers say, whenever, somebody's doing a Series A or a Series B, we're usually granting those institutions an anti-dilution right. Quite frankly, I don't believe in that as much, because, in reality, I think it should not be that, just as a matter of you investing this one time that you get forever, 5% equity. I really do believe it should be, if you want to maintain your 5%, we'll give you that right, to re-up and invest in the next round and be, definitely one of those investors, so that you actually get to participate and keep your stake at the level that it's at, right? But at the same time, anti-dilution can become, it can rear its ugly head in future capital raises. Usually, if somebody sees that somebody else was granted anti-dilution, they're going to ask for it too. And they're going to be like, well, technically, like, the fact that that person has anti-dilution further dilutes the rest of the investors that don't. So, it can become an issue. Whenever we're talking about anti-dilution, by the way, it's usually not as common with simple agreements for future equity and convertible notes. And I want to talk about the difference between these two instruments, because they're very similar. We have templates for these, where if you were looking at the templates, virtually the only difference between a simple agreement for future equity and a convertible note is what's called a maturity date and a maturity date conversion. A loan, by the way, every loan that you've ever seen, it has a maturity date on it. It's got a term, 2, 3, 5 years, something like that. Standard in startups is going to be that 2 to 3 year range. Sometimes it could be 4 years, right? Just keep in mind that, we want these, simple agreements for future equity usually don't come with maturity dates. Usually, they're activated and triggered based on a next equity financing. And, one of the downsides to that, I will tell you, is that a safe itself does not actually, will not convert unless that next equity financing is triggered. So, technically, if the company continues to raise money via safes, it could potentially never activate, it could potentially never actually activate the conversion language in there. And so, there's potential that some of these people will never convert into equity, which I don't think the investors really want that. At some point, they actually do want to convert into equity. They want to make sure that you're actually hitting those milestones. It is fully understood under these agreements that these people don't really get their money back, right? 99.9% of the time with a safer convertible note, it's either just going to stay out there or it's going to convert into shares. Usually we don't pay these things down with cash from the company, unless, of course, for some reason the investor wants to allow us to do that sort of thing. the convertible note, by the way. Okay, so three major terms. All right, with the convertible note, we're looking at, well, here are the major terms. I'll say investment amount, obviously, discount rate, which is usually going to be around 20%. And then we're going to have a valuation cap. The valuation cap is usually what's known as the post-money valuation cap. So we take the pre-investment valuation of the company. For example, let's say $1 million. We take the entire value, the entire round that we're raising. So let's say you were doing 250,000. The valuation cap that goes into this document would be $1.25 million. Okay, that's usually how we calculate it. That said, the valuation cap is a negotiable term. It is not set in stone. I have seen cap tables where the valuation caps were all over the place. And, but just so you're aware, whenever you're looking at the valuation cap for the company, it does affect the economics. I've seen people say you don't want to sign one of these that doesn't have a valuation cap in it. You want to go in with a capped round or a capped note or safe, because it provides more certainty as to the nature of the conversion. So effectively, the investment amount, the discount rate, the valuation cap, and exclusively with the convertible note, the interest rate, because that factors into the amount of shares these people will get. We basically take the principal and interest that's accrued, and we do the algebra and we calculate how much, basically, what the actual dollar amount is that's outstanding right now. And then we use that dollar amount to calculate the conversion shares. Okay. As far as the conversion goes, though, I would recommend, by the way, when I say a word on convertible notes from this past week, I do want to talk about a real life situation that actually, I think, puts one of our clients at a slight disadvantage. And I had to explain this to them earlier, actually yesterday. When I was reviewing these documents came from a large law firm, by the way. I'm not going to say the name because I don't want to disparage anybody, but the reality is this is not how I would have ever drafted it. And I would have negotiated really hard against signing, against anyone who had asked it to be this way whenever they executed these documents. I was reviewing this convertible note and it did not include maturity conversion language. It included a maturity date, but it did not include any other language which talked about a conversion upon the maturity date. Effectively, the convertible note said, in the event, that the note reaches its maturity date, then effectively one of two things needs to happen. If the next equity financing has not been met, then as far as the money is concerned, the company is obligated to pay the investors back. And then there was additional language which actually said that in the event of a default, meaning in the event the company could not pay back the investors in full, then with the consent of a majority of the note holders, somebody could send notice to the company that they were actually about to take possession of any of the money the company had and pay it to themselves to satisfy all or a portion of the note. That's problematic for obvious reasons, right? We don't normally allow rights such as that in these convertible notes, for a number of reasons. Number one, in the event of a maturity date, we need to actually allow the company, at its election to convert the note into shares to stop the bleeding. Okay. So keep in mind, when you have a convertible note, that goes on the liability section of the balance sheet. You literally have to log that, on your accounting in your financial statements and show, how much principal and interest you owe on these sorts of things. And if that keeps going up indefinitely and you can't actually convert that stuff into shares, that's a bit problematic, because whenever you disclose financial statements to investors, they're going to see that. And then, additionally, the issue with that form of convertible note was that, I think it would put the investors at future investors, it would kind of make them a bit wary of whether they should invest or not, because the language effectively says that because they can access the bank accounts and take control of any of the money in those accounts, the future investors are at the will of the previous investors in that situation, which doesn't make any sense, right? We don't want the future investment to be completely gobbled up by these people who are just satisfying debt, right? We're not paying for that. We're paying for the company to grow. And as far as future valuations of the company, that it does actually affect the valuation of the business, because effectively you've got massive liabilities, and you really have a lot of business risk there. I'd say if you ever have a cash event, you might as well just kiss it goodbye, because the moment the investors find out about it, they're gonna sit there and try to get their money back. So but that said, I don't want to say that it's always wrong to do such a thing, but I would say when I noticed it, I actually did ask a delicate question to the client, and I basically said, in the event you're ever like looking in the future to convert these into shares, you're probably going to need to get the consent of the majority of the note holders here to do that, because the contract does not address it. It's either that or the contract needs to be amended, and all of these people need to have an amended version of this, need to have an amended version of it. And when I got a response from that person, they basically told me, oh, we actually thought this would convert into shares. It's not what the contract said, which tells me that either their lawyer didn't explain what they were doing to their client, or their lawyer, maybe made a mistake and thought they were drafting an agreement that said this and didn't, which is a problem. I was talking to my business partner about that yesterday, Matt Jones, and I said I would never draft it like that, because you're just putting everybody who wants to be involved with this company at risk, except for those investors that hold the notes. The investor, and to be honest with you, the investors that hold the notes should really want to change that contract, because it benefits the company and benefits their investment. They're way more likely to make money on their investment if we alter it to include the maturity date conversion language. But yeah, those, we don't really see very many issues with these things. They're pretty standard. To give you an idea, I had somebody try to negotiate something weird into these convertible notes the other day, and I basically flat out told them that I wasn't going to agree to their proposed changes, because their proposed changes would have been red flags to future investors. I'm not going to do anything weird. They can't be easily put into a cap table. Okay, we need to be able to implement these contracts, not just sign them, right? So as far as this goes, though, there are pros and cons to this, right? So when it comes to simple agreements for future equity and convertible notes, one of the major issues with safes and convertible notes is the uncertainty around them, right? We oftentimes see that inexperienced investors don't understand them and resist them. And if that's the case, then what I recommend doing is just doing equity transactions. So stock purchase agreements or membership interest purchase agreements, because in that case, at least those people will know what they own, right? But as far as these go, though, the preferred method for a lot of these people is to do safes or convertible notes. But the general industry, by the way, is actually leaning way more towards safes. That's asked for way more by other people. And I will tell you, if you're looking at the economics of these transactions, typically simple agreements for future equity do not give as much do not convert into as many shares as convertible notes. And the reason has to do with the interest rate on the convertible note. When you look at the comparative timelines of those documents, 2 to 3 years versus potentially indefinite, usually the safes actually do get converted in 1 year to 2 years. It's rather rare that, they don't convert in that amount of time, because usually the people who are raising money via SAFE are about to go raise an equity priced round, right? And, I would say though that if you're looking to reward shareholders a little bit more than with one instrument versus the other, a convertible note might actually do it for them versus a SAFE because of that interest rate. Okay. We've seen certain businesses where the original ask when we were proposing, an early stage financing was very difficult because there was no other business. There was no precedent for, what a company like that might be valued at, because nobody was doing that sort of thing. We had some adjacent businesses that we could look at as an example, but we saw nothing. We saw nothing as far as, exact matches or very similar companies that were doing similar things. So, we said, okay, whenever we're explaining this to the investors, we'll explain that we chose the convertible note as opposed to the simple agreement for future equity because, we're going to reward the investors for taking the risk, right? It's either that or with the stock purchase agreement, you sell a little bit more equity, than you otherwise would, right? That said, one thing I do want to mention, consider the dilutive effect of SAFEs and convertible notes versus stock purchase agreements. I know for certain, how a stock purchase agreement dilutes the rest of the owners of the business or the rest of the stockholders. With a SAFE or convertible note, it kind of depends on certain factors. I can run a pro forma, but it's not going to be 100% accurate. I got to know, and I usually do run a pro forma, by the way, using some software that we typically use to make sure that, hey, the projected dilution isn't getting out of control to the point where, at a very early stage where the company is actually losing the original founders are losing control of the company because they don't own enough shares or, upon the next equity financing, right? When I say potential dilution can be extreme, it can. I did a $750,000 stock purchase, that was made into a Mexican fintech company, which, to be honest with you, that company, I think it's going to turn into $1 billion company someday. The market is there. Their business is there. They've got the foundation for it. It's just a matter of, getting additional financing later on and really growing and ramping. In that example, the original CEO was actually, when at the end of the day, when we had, converted all of the SAFEs from the previous round and then done the stock purchase, as well as, we issued 10% as far as an equity incentive plan. The dilution made it so that the original founder and CEO had less than 10% equity in the business, which if you're sitting there thinking to yourself, gosh, how could that happen? It happens. After 2 or 3 rounds, you could be sitting there if you're not careful and you're not pricing it smartly, or at least attempting to control the dilution, or potentially, paying out certain investors and buying back stock, right? One way to actually shore up the dilutive effect of, your next round is actually to say to your investors, hey, I know that, I'm going to be, pretty low on the percentages here after we do this. Is it possible you could give me stock options, right? That's actually a soft way to, and usually these people will say yes. They'll give you stock options that are vested over, a number of years going forward, so that you continue to be motivated and incentivized to stay with the company. Because I do think, once you hit that 10% range, 10 or 15%, a lot of people start looking for the exit, and they go, gosh, I own 10% of a company that's worth this much, but I'm really not worth that much. And so a lot of times they can actually just leave without, the company without needing to sell their stock back or anything like that. Do we have any questions about that? I was kind of rambling, but, I wanted to talk about this stuff generally because what most people understand as far as seed stage financing is that safes are the way to go. But I want you to be aware, like I said before, there are no absolutes. I've seen cap tables where all of the previous, equity, all of the previous financing was done via stock purchase agreement. And I will tell you, it is not wrong to do it that way. If you want absolute certainty of what everybody owns, just do a stock purchase agreement. That's fine. It's not wrong. And to be honest with you, I kind of like doing it that way because at that point, the math makes sense. We don't have to sit there and be uncertain, or, me as a lawyer, I don't have to answer questions about what's going to happen at the next equity financing, right? Aside from that, step 3, determine form and substance of the instrument. With convertible notes and simple agreements for future equity, that's pretty simple. We just, we need to settle on the, valuation cap and the investment amount and the discount rate. We need to settle on the interest rate for a convertible note. That's easy. Like we're not really worried about those documents because they're templates, and for the most part, they're generally accepted. We have standard versions, by the way, edited versions, I should say, of the Y Combinator safe, for example, in case anybody asks us for it. We tell them this is what we call Y Combinator Plus, and the plus is basically I, as a lawyer, looked at where it failed and actually edited it to make it better. Because people will ask for it and I'll be like, look, I understand you're asking for the exact Y Combinator safe, but I took all of the versions that they have of it and actually created a slightly tweaked version where all I did was adjust the boilerplate and adjust the definitions to make it clearer, right? Because it's good, but it's not that good. Y Combinator was the first to ever do a safe. They basically invented it, but as far as doing safes go, I actually do not prefer the Y Combinator safe because while it's okay and it's somewhat clear, it's not totally clear. Our agreements are actually way more clear on a lot of the issues. So aside from that, stock purchase agreements, though, in some cases, you're going to be looking at, granting people preemptive rights of first refusal, rights of first offer, anti-dilution. Like I said, I recommend against that in most cases, board seats or board observation rights. Now, I want to say specifically, let's say we were doing a safer convertible note round. Those last two, board seats, board observation rights, right of first offer, we might have side letters that are drafted up, or we might have, something in these agreements which actually does allow these people a right of first offer or right of first refusal. Okay. We can do that via a side letter, or we can incorporate it into the agreement itself. Either way works fine. I'm not really worried about which way it gets done because the effect of it is the same. It's a contract, right? Major investors might require side letters which talk about this sort of thing. We've had that happen to us, which is fine. Side letters, by the way, are a private equity concept. It's basically a contract on the side of a contract, right? And, it just refers back to the original instrument. And usually we do this when we have a situation where I can't modify the actual instrument, but I can, and I do have the authority to actually grant somebody, a carve out or a right for something else that I may not be granting to other people. Sometimes, though, you do need to get the consent of the other investors if you're going to be doing that. I recommend you always let them know that you're going to be doing such a thing. And if some people go, like, let's say somebody was putting $200,000 in of a $250,000 round, I would actually, if the remaining $50,000 we're asking for the other terms, sometimes we say yes, sometimes we say no. Sometimes that large investor wants to be the only one who has that right. In that case, we respect it. Sometimes I ask the investor, is it okay if we allow these other people to participate in this since they're going to be closing the round with you? A lot of times they'll say yes to that. I'm not, and to be honest with you, I'm not afraid to grant somebody a right of first offer or, board observation rights. Where I get a little bit more cautious and where I actually do start negotiating a lot harder is when we start talking about board seats, rights of first refusal, preemptive rights, and anti-dilution. I simply do not, especially on board seats, you better be making it rain on the company, if we're going to be granting that, or you better be a very knowledgeable strategic advisor, because the board seats are extremely valuable. You're basically voting on the direction of the company on a regular basis. You have duties that are similar to the CEOs in that you have fiduciary duties. And you're going to be signing indemnification agreements if we do that. It's a very serious matter to grant a board seat. So don't do it lightly. If you think the person is a strategic advisor, potentially make them an advisor. Okay. It's not necessary that we make them, it's not necessary that we make them a board member unless that person truly needs or wants to be there. Okay. Major invest, like I said, all of this stuff, is very high level overview. But as far as form and substance goes, I would say like your startup lawyer, should have these documents available and should have something to work with that, as a template is a good starting place to do this. If they do not, they're not really a startup lawyer, because you literally, like, the definition of whether you do this well is having these on hand, because somebody will come to us on a regular basis, literally almost daily, and say, we're about to take, an amount of investment. We're doing it via a safe, in which case it takes me 30 minutes to draft the safe, takes me 15 minutes to send it out for signature, takes me another 15 minutes to send everyone, executed copies of it once it's all said and done. Whenever you're doing these things, it needs to be that fast, because striking while the iron's hot is important. And also, I will tell you one thing that you should keep in mind: stock purchase agreements, as opposed to simple agreements for future equity and convertible notes, are going to be a little more expensive. Safes and convertible notes are very simple and easy to draft. They don't take as much time. Okay. So, if you're looking to reduce your legal fees, I would recommend, choosing one of those choosing the safe or the convertible note as opposed to a stock purchase agreement, because you're going to have a lot less in legal fees. There's going to be a lot less to negotiate on those. Okay. Where I see a lot of negotiation is on stock purchase agreements, because as far as I'm concerned, we see people who go, no, I want this. I want information rights. I want to be able to do all of this stuff. And then, in addition to a stock purchase agreement, I usually also have to draft a bunch of other ancillary documents, such as, a buy-sell agreement, an investor rights agreement, or a stockholders agreement, or something else, right? Which I talk about, here, in a minute. But, step 4, signing documents. Once you locate investors and they've agreed to invest, have them sign all necessary documents. This is a no-brainer, right? Unfortunately, it doesn't happen as often as you would think. Sometimes what we're doing is we are actually giving, a suite of documents, and that suite of documents is going to be, delivered by the company, and its CEO and CFO or whoever else is working for it. And they're going to be going out and, having those things DocuSign themselves. That said, I can sit there as well and have have everything sent for DocuSign too. Okay. That said, the reason why some of our clients don't like to do that is because it's way more expensive. But I as a lawyer try to supervise that sort of thing, because if I see that it's being done wrong, we have to go back and comply with securities laws. We have to make sure that the accredited investor questionnaires or the accredited investor certifications were signed properly and that we received proper information. We have to make sure that the wire transfers were made properly. Which, by the way, if you have an investment document such as an SPA or a convertible note or a safe, let's say somebody signs it and they don't pay you anything, and let's say you get to the next equity financing and you never canceled it. Well, you need to be able to cancel it, or you need to tell that person, hey, you're in breach. I need your money now, or you're gonna, or we're basically gonna have to, institute legal action against you to get the agreement nullified because you're in breach of the contract, right? You need to be following up with payment. It happens regularly, not all the time, but it happens more regularly than you would think, that somebody signs a document and then later decides, no, I'm not going to pay that much money for this. I'd rather give you, $25,000 instead of $50,000. At which point we either need to sign an amended version of it, or we need to come to an agreement that we're canceling the previous agreement and we're going to sign a new one, right? But yeah, as far as the importance of these documents go, I want to stress the importance of the subscription agreement in the investment agreement, but also the accredited investor questionnaire. It is up to the company, because of securities compliance, to make sure that they are verifying the accredited status or the non-accredited status of their investors. And that means literally asking these people, basically, are you rich? Do you have, do you make $200,000 or $300,000 a year, as a single individual or as a married couple, or do you have $1 million in net assets, minus the liabilities on your homestead, right? And any other investment property, right? When we're looking at accredited investor status, if you're doing what's called a Rule 506B round, you can have unlimited accredited investors, but only up to 35 non-accredited. And then with a Rule 506C round, you can have unlimited accredited investors and 0 non-accredited investors. Why is that? Because under Rule 506C, you are allowed to do what's called general solicitation. You are basically allowed to post on Facebook. You are basically allowed to advertise on social media that you are raising a round. You're allowed to tell the world that you are taking investments in your company, and that you are looking for people who have money, right? That said, I highly recommend that you go with, if you're doing Rule 506C round and doing general solicitation, I highly recommend that you go with some software that supports that sort of thing, so that you can verify these people's accredited investor status automatically without having to sit there and get a verification letter, or without having to request additional information. That said, in the event you're not going to do that, or in the event you need to, sometimes you actually do need to get a verification letter. I, in the past, have actually provided verification letters, right? I've provided verification letters for individuals, and I've literally, when I do that, I say, okay, I need screenshots of your bank accounts right now, all of them. Which a lot of people go, oh, what, really? Yeah. I need to know how much cash you have, because I'm about to run an Excel spreadsheet and I'm about to do the math myself. I also need to know, what homes you own. I need to know which property you own as far as real estate goes. I also need to know how much in mortgage, payments you have left, right? We have another question. Let's go ahead and throw this up here. If you're treating the money that you're receiving from investors as a loan, do you have to still follow SEC guidelines, documents, contracts? Potentially, yes. It depends on how long the term of the loan is. Usually, if it's longer than 9 months, or whether it's secured or not secured, then there are certain things that make it a security. That said, because a convertible note is indeed a loan, it's a promissory note. Because the expectation is that you're going to profit off of the efforts of others. Technically, for a convertible promissory note, you're looking at technically with a convertible promissory note, you're looking at a security. So safes are securities, convertible notes are securities, so are stock purchase agreements. Okay. When it comes to that, you do still have to comply with securities laws. I think a lot of people misunderstand that. I was actually reading the note purchase agreement, which is a separate document, with those convertible notes that I was talking about on a previous slide from that large law firm. And somehow they were saying that, there's no need for us to qualify for an exemption under the agreement, which was not the case. I actually had to tell the client, to my knowledge, as a startup attorney, whether it's a safe or whether it's a convertible note or whether it's a or stock purchase agreement, you still have to file Form D. Usually, we want you to file Form D too, because it's, you're treating this as an investment, and most of these people are, passively investing in these companies, not actively investing in them. And most of these people, they're signing these instruments and they're not taking on any management role, right? It meets the definition of what's called the Howie Test, efforts from others, for security, I'll tell you. Okay. Aside from that, going forward, securities filings, like I said, this is very important. Aside from what goes into these contracts for investment, this is the most important step, really. obviously, protecting the company and protecting the people that run it, and making sure that these investment documents are worded the way they should be is extremely important. That's really step number one, or that's really priority number one is make sure that those are tight, right? And then priority number two is make sure that once the time comes, you are actually following up with your attorney or making the Form D filing as you should be. And this is extremely important. Whenever you file Form D, you're going to notify the federal government basically that you've complied, you've substantially complied with all securities laws. You're basically signing an affidavit, okay? You're signing a statement of fact and attesting to that fact that you have actually done what you were supposed to as a company in order to do, a legal, exempt securities offering, right? And a private offering, not a public one, right? And then, as far as, like I said before, Rule 506B versus Rule 506C, those are the most common. So if you don't know anything about that, I'd highly recommend you read up on it a little bit. You don't need to be an expert in these sorts of things, but it actually does help when I'm talking to customers and potential clients or current clients that they actually know what securities exemption they're going to fall under, because it makes us fundraise, like it makes the fundraising process go a little bit more smoothly because I can tell exactly what we're going to do. But a word on filing this. So this creates a presumption that the company has done what it's supposed to do to be exempt from registering the offering, or to be exempt from registering the offering with the SEC or other regulatory agency. And I want to clarify that statement really quickly. So when we file Form D, we are not effectively legally registering the offering. That is not what we're doing. We are filing notice effectively to the SEC that we have complied. Okay, those are two different things. When you register an offering, you're filing a different form, and you're effectively saying, we are registering, this public offering, or we're registering an offering, that does not fall under one of these other exemptions, right? Technically you could potentially be required to register a private offering. That said, for the most part, most people are able to comply with Reg D, when they're raising money. Whenever you're doing this, it really is ultra important that you check this box and, hit this step. Okay. Because if you don't hit this step, unfortunately, you're going to have some issues where well, I'm not going to say that definitively, you could potentially have some issues where these individuals who are investing in you, if they believe that their money was squandered or misused, or in general, like they believe that you have not done what you were supposed to do as a CEO, they could potentially cite the failure to file a Form D and comply with securities laws as cause for having their money back, right? So they could effectively argue that the company itself and the people who run it, if they've earned any money from the company, should be disgorged from the investment itself. Effectively what disgorgement means is pay it all back plus interest, and the interest would be at the statutory rate, based on whatever the SEC is telling you, as far as laws you broke. And I will tell you, if you were the subject of an enforcement action by the SEC, they're very exacting. We had a client actually, and this is a different agency, but we had a client that early on we were looking at forming a cryptocurrency hedge fund. And then, eventually we realized that most of the compliance issues that one of their existing businesses had some serious compliance issues to the point where we were unable to actually really do anything that we would normally be able to do. And my role exclusively began searching for large law firms to represent this person so that they could self-report certain issues. But that said, what ultimately happened is, one of the agencies instituted an action against that person, which, is not what we wanted. But it appeared that, there was some investigation into certain claims that might've been made by, people who were involved, with the company. And so as far as actually complying with this sort of thing, it's vital. at the very beginning that you do this. You don't really want to, make any progress as far as investment or talking to investors before you've, put this in place, right? It's possible you can go have a conversation with somebody, and, if that person expressed interest, you might be able to go to your lawyer and, get all that drafted up. But I would highly recommend that, you prepare the offering and figure out how it's going to go, or at least, figure out which investors might be interested in investing in you, or at least coming to an agreement in principle with one of those before you go and get the initial documents drafted up. Because it's just, and by the way, whenever you take that first investment, you have 15 days to file Form D. Does that always happen? I would say not always. A lot of times it doesn't. When we look at most of the people who do this stuff, a lot of times they miss that 15-day deadline by a mile, by the way. I saw one the other day where, the 15-day deadline was missed by like a year. That said, in the event you miss that 15-day deadline, you can always go back and file it. And you should, because quite frankly, if you believe that you complied with, all the other securities laws, technically it's not a violation of, technically the SEC has issued guidance that says, yes, you can still do this. That said, the timing of it might, cause some other issues, but, at least you will have filed it and the public will be on notice that you did, which, by the way, these are searchable. We've run into situations where we're in the middle of a round and, for whatever reason, the filing didn't get done by day 15. And, and we ended up just going back and, making the filing because the investor was saying, I'm not going to invest until you have a Form D, so that's what we did. And, as far as we are concerned, that's compliance, right? If you previously failed to file, like I said, do it at any time if you can. There's no expiration date on that. Okay. Notify investors of your compliance with Form D too. Okay. Part of keeping investors happy is just communicating with them regularly. Send them a copy or link to the filing. They can see it. They can see it on Edgar. Okay. They can search it. So just go ahead and do that once you've done it. All right. And you can, usually people will file 2 of these, right? They file the initial one on the first investment, and then they file an amended one at the end of the round, right? It's from what I understand, because we do this all the time, it's not totally essential after that first investment that we do, an updated Form D every single time. But, what I would say is, incrementally, it makes sense, especially if we're raising money over a large period of time. So we might look at it and check in every 3 months, over the course of an entire year of fundraising, and actually just say, okay, Q1, Q2, Q3, Q4, we make those filings, then we close the round at Q4, right? Aside from that, step 6, closing of round, closing binders, and post-closing. Typically, whenever you close a round, you provide what's called a closing binder to these people. You're going to be providing them with, all of the executed documents for their records. Sometimes we end up providing the entire suite of documents to all of the investors in the round so that they can all see, what other terms were in there. Obviously, the nature of these things is pretty confidential. Usually there's confidentiality language in the agreements themselves. So, there's really no sharing outside of the company or outside of the investors, that goes on with this sort of thing. But it's important to give everybody closing binders because we want everybody who is involved and gives money to have a record of this for their purposes, so that the company doesn't get some weird demand for books and records, right? Which I want to talk about. Post-closing duties. Most companies provide monthly or quarterly updates to their investors. This is normal. I'd say monthly is more normal than quarterly, but both are technically correct here. You want to check in with these people. You want to make sure that they're kept happy. Number one, because, it keeps them informed and engaged. Some of these investors will ask questions. They'll want to know, hey, how can I help if I can help at all, right? Or, hey, what's the timeline for the next investment? What's the cash, reserve look like, for the business itself? How much runway do we have left? Some of these people are interested and just want to understand how they can best, assist the company, regardless of whether they have a management role or not. And I do want to say, though, you want to make sure that anybody who is not given a director position or is listed as an advisor, and assigned an advisor agreement, is not acting, in that capacity and conducting any sort of, or managing the business really in any way. It's okay to give feedback. It's okay to give feedback on an investor call, but it's not okay to get that person, give that person a management role unless they're officially made an officer or unless they're officially made a director or something else, right? Help prevent, this helps prevent lawsuits or demands for books and records. So number one, on the lawsuit front, yeah, like you can actually, like, even if things are going poorly and, the investment, looks like it's about to go bust, well, at least you've given them information on all of that. And the argument becomes, you've never withheld anything from them. You never withheld anything material from from your investors, or never withheld anything that, that they had a right to. So if they have information rights in a stockholders agreement or information rights as a result of a side letter to a convertible note or a safe, you might be looking at, you do need to provide them with that level of information, and you need to make sure you are absolutely giving them what the contract demands. If it comes up anywhere near short, that's breach. I will tell you, you don't get to half-ass it, and you don't get to go 99% and not give them this one little tidbit that's required by the contract. You must do it. Okay. Demands for books and records. In my career, we've only ever had to send one of these on behalf of somebody, and we were actually successful when we did it, which is actually very risky for the law firm. Whenever we do this, we have to make sure that it's, based on the current case law, that the demand for books and records is very specific, that we legitimately have a cause of action for sending it, and that what we are demanding is actually deliverable, and that we're not going to be creating some sort of litigation issue that will ultimately result in the person we're sending it for being subject to pay the other party's attorney's fees. Which, by the way, if you send a defective demand for books and records, you will be required to pay that person's attorney's fees if it's found in a court of law or by an arbitrator that you fail to meet the threshold that the law requires for that sort of thing. But whenever you keep people informed, they don't need to demand books and records, because they don't need to see the books. They don't need to see any of the other stuff, because you've substantially, filled them in. If they do that and you say, technically, I've already provided all of this information to you, you can choose to comply with it and just tell them, look, hey, we've already done all of this. So I don't know what you're sending this for, but here's all the information. Also, here's all the stuff from all of the other investor calls, all of the other, from all of the other investor calls and all of the other investor meetings and the board of directors meetings and things like that. Usually when we're looking at this, it's usually when a dispute arises between, somebody that was instrumental in the formation or the founding of the company, and, somebody that leaves or gets pushed out, or in the event, something happens where, the investors believe that they might have been defrauded, which, fraud is usually, one of the allegations that gets made. It comes up the most, I'll tell you. And then, it creates standard of delivery of company information that should be maintained going forward. If adjusted, you should notify all investors in writing to manage expectations. To give you an example from from the previous demand for books and records that we sent, part of the reason we sent it was when, the founder of a company got pushed out by the investors. This founder owned something like 35% of the company ish. So they were the largest minority investor out of the entire company. They were the original founder of the business. They previously had sent monthly investor updates on a certain date of the month. And when they got pushed out, that stopped. And then another month went on. And then no information was received by any of these stockholders. And there were quite a few of them. And one of the things we put into the demand for books and records was that fact itself. Previously, it was the standard of the company to actually do this. You took over. We said this person took over as interim CEO, and and made themselves CEO as a result of all of the stuff that went down, and stopped doing all of this. And then what ultimately happened is we started hearing things, which it's common to do. When something happens like that, the former employees tend to start leaking information out of the company, just on their own, and without any sort of solicitation from anyone. And we eventually find out that they're running or basically mismanaging the company because they have no idea what they're doing. So whenever these things come up, it's very important that you post investment, keep these people informed. While these people might not have information rights as stockholders, it's okay to tell them stuff. And to be honest with you, people who've given you 50,000 or 100,000 a piece want to hear from you. Like they want to know that things are going right. They want to know if, potentially if they've got, additional capital to spare, if they should invest again, right? And sign another convertible note or another safe, right? So we're actually approaching, sort of the end of our time here. So I actually was planning to get to Series A transactions, but I guess I talked, at length about all of the stuff that we have for, for seed financing. Does anybody have any questions about seed financing? Because I have about 10 minutes left to talk about Series A, and I'm going to, go through this pretty quickly because a lot of it's going to be very similar to what we talked about previously. Either way. So as far as, like typical size of transactions, here's some data. Median in 2020, 2.2, 2019, 3.9. This is for seed financing. And then, 2/3 of company closed seed financing generated revenue at the time, up from 9%. I want to state a caveat here. Statistics are wild in VC. Like I literally, like if you look at one website versus the other, the information is totally different. The way it's presented and the metrics they're using, I have no idea, which of these is actually closer to the truth because the data aggregation is just so off. There's really no, industry reporting for this sort of thing that's affirmative. And so we're having trouble, figuring out the actual numbers for a lot of this, I'll tell you. But typical size of a Series A. So median Series A stats from funds.net, 12.4 million in 2019, 11.9 million in 2018. And, so basically we're looking at more than double from, over a decade ago. And that's just, because I think the startup market has at least solidified quite a lot as far as investment goes. People understand, how to make money more clearly, I think. And so they're more likely to push money into these businesses. I will say, though, that a lot of these businesses are getting higher valuations than they were previously. So, and there's a bit of a disconnect and kind of some contrarian views, depending on the type of startup we're looking at. So, for example, one company we might like take a look at, a ballpark valuation, but really, we're applying a 10x multiple to earnings or something like that, or a 20x multiple to earnings because of the industry. In other situations, we're looking at, I've seen it where some people, including our clients, have told us, no, we're not going to, we're actually not going to make revenue yet. Because quite frankly, the moment we start making revenue is the moment all of these people who are going to invest in us are going to argue against our valuation, which to some extent is true. Once you have revenue, you can actually do a better estimation, do a better guess on what the value of that company might be. And usually, I will tell you, like the companies that we see that are most profitable are quite literally, getting the lowest valuations somehow. Like apparently cash flow does something to a business where it destroys, the ability for you to get that higher multiple, right? That's a problem in my opinion, because quite frankly, it means that, it means that these companies are going to seek capital at a higher valuation and run longer at a loss, as opposed to trying to earn money on their business. But the flip side to that is some of these businesses, because of the way they're monetized, it's virtually impossible to do it until they gain so much market share that literally no one else can really feasibly compete with them in any meaningful way. We have clients who are in that situation where they're completely holding off on charging the customers money. They're completely holding off on creating any additional value add with money, like or doing advertising revenue if they're a social media business, because they're worried about the user experience of their software or their app, and they're worried about eroding their customers and their user base. So some things to look into as far as Series A process. If one thing I do want to say, let's say, for example, you did a seed round, but you didn't use a lawyer when you did it. In that case, the first step is really cleanup. When you're doing a Series A, I don't really recommend that you do it without the advice of an attorney, because at this point, we're most often going to be doing stock purchase agreements, and priced equity rounds, as opposed to convertible notes or safes. And the reason for that has to do with the Series A is going to be valued so highly that we don't really want to do a simple agreement for future equity. We'd rather the investors just be certain as to what they own. And also, it's usually high time that we convert the previous safe holders or the convertible note holders into equity as well as a part of that transaction. But due diligence, make sure you got a clean cap table, make sure you have your certificate of incorporation and all of your other corporate documents. Equity incentive plan is key. We need to know if you have one. Also, if you don't have one, you need to tell them, because usually when we're doing a Series A, if there is not one or it's not big enough, we're going to have to issue additional shares or create the equity incentive plan in order to get that business, to where it should be prior to taking the money in. And then, major contracts, you might have to have those on hand just for disclosure purposes. Usually investors will create what's called a data room. The data room will have a bunch of different, key stuff that, they need as far as documentation goes. You also are going to need to have financial statements. So at some point, you do need to make sure that you have, accounting software assisting you with figuring out, all of your tax deductible expenses and making sure that, you have a profit and loss that's getting pushed to you every single month. You just need to have the basic process of creating financial statements set up, because if somebody asks you, you need to be able to produce it on command. Term sheets, the term sheet itself is an important part of this. Some people skip straight into the investment, but I think the term sheet is very helpful because it helps us with the early negotiation and the high level bullet points. But you want to be pretty detailed about what you want in the term sheet, because if you're not detailed, we're going to have to, go into further discussion on the terms. Once the due diligence process is done, at that point, most of the investors, especially institutional investors, will try to go and, propose their initial term sheet. A lot of these people want to make the first move on that because they've got their own method of doing that. They have what they're comfortable with and what they've told their investors, their criteria is going to be. So they're going to actually, they're going to go forward and, propose it. And then it's going to be up to the company to come back with a revision, come back and negotiate the stuff. And on Series A, you should negotiate. Some people will just say, okay, yeah, that's fine. Would highly recommend that you at least look at the terms, make sure they economically work, make sure, implementing them is feasible, make sure that, you're protected and your interests are protected, right? And these are just the major terms. I'll let you read that. But aside from that, it looks like we got about 2 minutes left. Drafting the transaction documents is the next step. This is obviously where things get more difficult, but usually we use some pretty standardized documents for this. I've seen people in the past use, we have in the past used NVCA in model legal documents. And basically, if we style the term sheet based off of the National Venture Capital Association term sheet, that can make things a lot easier and a lot less expensive. It can also save all the parties a lot of money because we won't have to sit there and say, oh yeah, somebody charged you $50,000 in legal fees just for the sake of, like we had to charge somebody 50 grand in legal fees so that, for a deal that never really went through. We usually want something in there, especially if we're representing the investor, by the way, we want to make sure that the investor is getting a certain portion of their legal fees paid for. To give you an idea, the last transaction I did for, a series seed came with a provision that guaranteed our legal fees in the amount of $20,000. That was regardless of whether the transaction went through or not. Okay. Be willing to get creative to solve problems. This is not one of those things where we need to sit here and say that every deal needs to be the same. Every deal needs to be rubber stamped. Here's what it must be. But, I would say work with each other, collaborate. And like I said, be a deal maker, not a deal breaker. Literally, so many people just get in their own way when they're negotiating this stuff and refuse to be reasonable on the terms. And a lot of times we see them lose out on opportunities because of that. Okay. Like I said before, execution and post-closing, make sure you get all the consents, make sure you do the securities filings, and make sure you give copies of the documents to everybody. I think we're out of time. But, as far as this goes, if any of y'all have any other questions about seed financing or Series A financing, feel free to hit my email at kyle@joneskertz.com. I'd love to talk to y'all about what we know about this sort of thing. And, potentially if you're in, the market for such a thing right now or about to raise money, I can coach you on some of the, key things to do, for your business if you like. Anyways, take care. Have a great rest of the month, guys. And we'll see you December 7th of next month. Bye, guys.